Good morning to all of you. Welcome to Legal Matters by Sai Babu Sunkara. Honorable Supreme Court of India on umpteen number of times clearly stated that if a person is illegally detained or if a person is confined in the jail beyond the period of sentence, it amounts to violation of Article 19D of the Constitution of India, that is right to movement, or it also infringes the right under Article 21, right to liberty. So it is definitely a human right. So if violation of human rights are there, definitely you can approach the NHRC, SHRC or the human rights courts also for the violation of the human right. Right. So an incident has come where the person, a rape convict, has been incarcerated in the jail for more than the sentence period. Therefore, Honorable High Court of Himachal Pradesh, Supreme Court granted 7.5 lakhs compensation to the victim. Who is the victim? Not a rape victim, rape convict. Here, rape convict has become the victim. So you can read the case as Bhola Shankar or Bhola Kumar, I think. Bhola Kumar versus State of Chhattisgarh in Criminal Appeal number 937 by 2022 on 9th May 2022. Justice, two judges bench, Ajay Rastogi and C.T. Ravikumar. They directed the state of Himachal Pradesh to pay 7.5 lakhs as compensation to the rape convict who has become a victim in this particular case. Right. So, as far as the case facts are concerned, Mr. Bhola Kumar is not an ordinary man. He was convicted in a case of rape and assault on this SC woman. So, he was convicted in section 376 IPC as well as section 3110 of the SC/ST Trust Act. He was convicted for to suffer sentence for 12 years. 12 years rigorous imprisonment. He has gone to jail. Okay. Normally, will he keep quiet? No. He has applied or he has appealed the matter. Of course, High Court also dismissed the appeal but reduced the sentence to 7 years, I believe. Yeah, reduced sentence 7 years. And actually, according to 357 CRPs, that is victim compensation, High Court ordered him to pay 10,000, ordered to pay 10,000 to the victim. If not, he has to suffer sentence for 1 more year. First, the sentence is 12 years by the trial court. Then, by High Court also confirmed the appeal but reduced the sentence. So, now he is convicted for 7 years. But this happened here, I think 2008 or so. 2008 or 2012. The 2012 matter. Right. Whatever it is, now the problem is, right, the conviction was given by the High Court, that 7 years on 19/7/2018. So by now the period is over, but he is in jail. Of course, he also did not know that the period is over. He has filed an appeal before the Supreme Court. When the matter has come before the Supreme Court, the advocate has raised up the issue that he is being confined, Your Honor. Already High Court has given 7 years, but still he is there. Then the Honorable Supreme Court of India asked the superintendent of the concerned jail, that is Ambikapur jail, Superintendent Ambikapur jail, he was asked to file an affidavit regarding the sentence of, regarding the stay of the so-called rape convict Mr. Bhola Kumar. Now the real fact has come to light. Superintendent said that here, without remission, this man has spent 8 years, 1 month and 29 days. But suppose if you take it as with remission, it comes to, please remember, 10 years, 3 months and 16 days of custody. The Supreme Court has taken a very serious note of it. Don't you know that he was, the sentence was reduced to for 7 years. So for this, the superintendent said, we did not receive any copy of the judgment of the High Court. But whatever it is, So he wanted to take the plea. After 7 years, this man did not pay that 15,000 compensation to the victim. So therefore, he stayed for 1 more year. That means 8 years sufficient. 8 years, but 1 month and 29 days, almost 2 months. So definitely it is illegal detention. So Supreme Court clearly. So now Supreme Court asked, how can you feign ignorance, FEIGN? How can you feign ignorance of High Court judgment which was delivered on 19/7/2018? So please remember, when a competent authority reduced the sentence, then the convict cannot be detained for more than that period. He should be set out after the completion of the reduction of sentence is over. So the state it is fault. So when it exceeded, it is a violation of article, already in the beginning I told you, violation of article 19(1)(d). That is right to move freely. But and also article 21, right to personal liberty. Therefore, for the sufferance or for the mental agony he suffered during the jail period, and also the pain caused to him due to the illegal detention, so state has to compensate the same by paying 7.5 lakhs to the rape convict, right? So here, why the state is liable? State is vicariously liable, and the state can collect the so-called amount from the concerned authorities. Vicarious liability, Article 300. The state can be sued and the state can also sue. That means already in the law of torts I told you about the vicarious liability. So due to the connection or due to the relation here, employee versus state, in that person definitely vicarious liability is there. As far as interpretation is concerned, please remember, all the so-called interpretations must subserve and help implementation of intention of the act. That means to say, while interpreting, while taking up the interpretation, definitely you have to look into the intention of the legislature. That's more important. You know, we have been discussing in the interpretation classes. So please understand, look into the intention of the legislature before interpretation. When interpretation comes, when there is an ambiguity, when there is a confusion, when you are not able to understand the essence of the meaning of the statute, then you have to go for the interpretation, which is the main job of the courts, right? Now, here, Honorable Supreme Court of India, using their powers under Article 142 of the Constitution of India, which says the court can grant appropriate relief when there is a manifest illegality. So, placing reliance on the important case, A.R. Antule versus S.R. Naik, 1988, Honorable Supreme Court of India was pleased to grant compensation of 7.5 lakhs to the victim, which has to be paid by the state. Of course, state is at liberty to collect from the salaries of the concerned jail superintendent or whoever it is. So, very good judgment. So, please remember, before discussing this case, please remember very famous case of Rudolph Shah. You may be knowing Rudolph Shah. What happened? He was acquitted in a case but kept in the jail for 14 years after acquittal. So this is nothing but illegal detention. It is against to human rights. So please remember, very good case law. This is a very good case law where Honorable Supreme Court has imposed a fine of 7.5 lakhs on the state for their negligence or for violation of the human rights. So please remember, Supreme Court will definitely take serious note if any violation of human rights is there. So if you know this much is sufficient. Thank you very much.